Kit, it's you. Good. Thank you. Your name, sir?
Justin Heaton.
Right away, this hearing starts with Justin Heaton stepping into dangerous legal territory, representing himself in a felony case. And Judge Simpson wastes no time making the stakes crystal clear. This is not small claims confusion, not a paperwork mix-up, not a say your side and go home situation. Heaton is facing 2 felony counts of assaulting, resisting, or obstructing a first responder or police officer, each carrying serious consequences. The judge's first job here is not to argue with him, not to coach him, and definitely not to rescue him from his own strategy. It is to make sure he understands what he is choosing. And that choice is huge. If you represent yourself, the court holds you to the same standard as an attorney. That means procedure matters. Timing matters. Knowing what comes next matters. And from the first few exchanges, the courtroom tension is already building because one question is hanging over everything. Does he actually understand the system he is trying to navigate?
And sir, you were intending on representing yourself?
Yes.
Pardon?
Yes.
All right. I do have to advise you that a couple of things. First of all, there is some danger in representing yourself. You'll be held by the same standards as an attorney in courtroom. The court is not here to assist you in that matter. I will presume that you would know the court rules and the manner and procedures. You understand that, sir?
Yes, Your Honor.
All right. I do also have to advise you that you're here on 2 counts of assaulting, resisting, or obstructing a first responder or police officer. You understand that, sir?
Yes.
Both of those are felonies, punishable by up to 2 years incarceration, a $2,000 fine plus court costs. You understand that?
Okay.
Right. If at any time during this procedure you wish to be represented by an attorney, all you have to do is ask the court, and the court will be more than happy to make sure that you are afforded counsel. You understand that?
Yes.
Do you still wish to proceed on your own? All right. What would you like to do in this matter?
Well, I was hoping to see if you were able to remove me from the jail today.
You're asking me to reduce your bond?
Yes.
Well, even before I get there, I have to do something with the case. What would you like for me to do with the case, sir?
Well, seeing as I was hoping to be removed from the jail so that I could better prepare for the case, that was my best wishes.
You don't know what procedure comes next in this process, do you?
And there it is. Judge Simpson says the quiet part out loud. Heaton came in asking to be released from jail so he could prepare for the case, but the judge immediately spots the deeper problem. He does not appear to know what procedural step is even next. That matters because a courtroom is not just about telling the judge what you want. It is about motions, examinations, discovery, bond standards, deadlines, and legal consequences. Heaton's request may sound simple, let me out so I can prepare, but the court still needs to know what he wants done with the case itself. This is exactly why self-representation can become dangerous fast. The judge is not insulting him here. He is warning him. And viewers, be honest. If someone is facing felony charges but cannot clearly explain whether they are ready for a preliminary exam, should the court let them keep going alone?
I assumed it was on the court. Yes.
Pardon?
I assumed it was on the court to decide that, yes.
On the court?
To decide the next procedure.
Sir, do you want to be represented by an attorney? If for no other reason than to assist you in this matter, I have some serious concerns that you're not sure what you're doing. And I'm not saying that in a bad way. I just don't think you know what you're doing.
Okay.
Okay, what?
No, thank you.
Okay.
I thought that I stated my claim fairly standardly.
Do you want a preliminary examination in this matter?
I was just speaking to my best wishes.
The next thing that will happen is the preliminary examination when the case is ready to go. Are you ready to have your preliminary examination?
Proceed.
Pardon?
Proceed.
Proceed. What's that mean?
I'm ready to proceed.
You're ready? Have you seen the discovery in the case?
The only paperwork I have is right here. It's the
Your Honor, our office has not really been able to deliver discovery. We would be asking for at least one of the jurors to make sure Mr. Heaton has studied. Right.
Understand that, sir? You haven't seen the paperwork in the case, right?
this is the paperwork that I did request proper paperwork before today. Yes.
You requested it from whom?
Now the hearing shifts from confusion to evidence, and that is where things get even more serious. Heaton says he requested paperwork, but Judge Simpson immediately drills into the basic question, from whom? Because in criminal procedure, saying I ask for paperwork is not enough. Discovery has to come through the proper channels, and if the defendant has not seen the police report, videos, or evidence, then moving forward with a preliminary exam becomes risky. This is the court trying to prevent a procedural disaster. A preliminary examination is where the prosecution must show enough evidence to move the case forward. If Heaton has not reviewed discovery, then he is walking into that hearing blind. And the irony is sharp. He wants freedom to prepare, but he also refuses an attorney who could help him understand what preparation actually requires. Judge Simpson is clearly trying to keep the process fair, even while Heaton keeps resisting the safest option available.
From the jail upon...
From who? All right, sir, you haven't seen a police report or anything like that, right? So you don't know the particulars of the allegations of the charges here. That was a question. You don't understand that, correct?
I would just not like to answer.
Would you like a copy of the police report?
Before we proceed with the case today?
At any point. Sir, I'm going to ask you again. Do you wish to be represented by an attorney?
No.
All right. What I'm going to do, however, is I'm going to, out of fairness, grant the request of the people to adjourn this matter. How long will it take the people to get paperwork to him so that he can be as prepared as he would like to be to proceed to exam?
We will get that over as soon as we can. My understanding, there are also videos that may take a little bit longer.
Well, I'll give you 2 because they're going to have to arrange a way for him to look at it. And I don't. Probable cause conference, court's going to find good cause to do so. I'm going to adjourn that to June 4th, 2026, 9 a.m. Bond in this matter will continue. Thank you. So that we're clear, I'm denying the request to release the defendant at this time.
Judge, I was just appointed, but I did meet with Mr. Fuqua yesterday for a good hour and a half. I know what the situation is. I have all discovery. Want to
Have it all?
want to set this for exam.
All right.
Now we move into a different defendant's matter, and the contrast is immediate. Unlike Heaton, this defendant has counsel, and that attorney comes in with discovery, a client meeting, and a clear plan. That alone changes the courtroom atmosphere. Instead of the judge having to explain each procedural step from scratch, the attorney is ready to address the court directly, set the matter for exam, explain the facts, and argue bond. This is where defense strategy becomes visible. The attorney is not denying that the case is serious, but he is framing the situation in the most favorable way possible. Older pickup truck, no plate, Valid license, cooperative stop, firearm allegedly found in the truck bed, and the defendant claiming he did not know it was there. That is not just storytelling, that is bond advocacy. The defense is trying to show the judge this person can be safely released under strict conditions.
People have their witnesses available to second? All right.
Judge, may I address bond?
Yes. Preliminary examination in this matter will be set for June 2nd, 2026, 9 a.m. before Judge Washington.
Oh my God.
All right, go ahead, Bond.
Just very briefly, my client was driving. He had just bought this older pickup truck, did not have a plate, which was the reason for the stop. He does have a valid license. That being said, he was pulled over. He was cooperative with the police. In the back of the pickup truck, in the bed, which had a tarp covered, they found a pistol. It did not belong to my client. He did not know it was there. There was also ammunition that was not correct for that gun inside the cab, which my client admitted having. That being said, sole caretaker of his mother, actually Trinity Health, his mother's caretaker. She now lives in an apartment temporarily while the house they did live in caught on fire and is being rebuilt. All that being said, Judge, I'm asking if
Going to be an objection to release him, Bob?
There would be. The people are gravely concerned given the allegations in this case. The firearm that was found was a printed gun.
Was what?
The gun, meaning there's no ability to track it. There could be the ability to have some additional firearms in the future. The ammo did not match the gun. That could suggest that there was an additional firearm that was not found. The ammunition that was found were hollow point bullets, meaning that they would cause grave bodily injury if they were shot at a person. The defendant was,
But not illegal.
The prosecution pushes back hard here, and the argument is simple. This is not just about a gun in a truck, it is about risk. The firearm was described as difficult or impossible to track. The ammunition allegedly did not match the gun, and the prosecution suggests that mismatch could point to another firearm not found. Then comes the detail about hollow point bullets, which the prosecutor uses to emphasize potential harm. Now, defense immediately cuts in with an important point, but not illegal. And that moment matters, because courtroom arguments often turn on exactly this distinction. Something can sound alarming without automatically being unlawful by itself. But prosecutors do not only argue legality at bond hearings, they argue danger, public safety, and risk of future harm. So the question becomes, should a judge focus more on what was technically illegal or on what the total facts suggest about potential danger?
Okay, go ahead.
the defendant was an initial offender by 1988. He has 3 convictions for homosexual conduct seconds.
When was his last conviction?
2000. In 2000, he spent 18 years in prison, Judge. He's been on parole since 2018. Judge, got off. He was off parole in 2018. I'm sorry. I'm just asking for it. He did show the officer that the guy did sign off on the title, just hadn't got a plate yet. I'm asking more just for leniency because this is sole care.
Just buy the truck? Is that the deal?
Yes, Your Honor. It was a used truck. He had just bought it. Yeah, the person signed off the title. Because he's a sole caretaker of his mother who's temporarily living in an apartment while their house is being built. He's agreeable to home confinement, tether, anything the court wants to give because he's going to stay there with his mother while he takes care of her.
He's not currently on parole.
Correct.
When was his last conviction 25 years ago? Or longer than that?
Yes, Your Honor.
No information to see that.
Well, look at your bond form. It says he's a convicted felon, heavily assaulted, dangerous criminal history, but so I'm trying to figure out why the magistrate set a $250,000 bond on this case. And it seems that that's the basis for it. But my understanding, at least as of now, is that was over 25 years ago. Or the conviction actually may have been before that, but 25 years ago. And he has no convictions in those 25 years.
I'm being told the date was 2003, but so it would be.
Okay, so 24 years ago or 20, whatever.
Judge, he would, to be honest with the court, he was in prison for almost 15 years. He was released. He got off parole. He was paroled. He's got off.
When did he get off parole?
2018.
And hasn't had anything since?
No, Your Honor.
Where does he reside? In Ipsy?
It's temporarily, Your Honor, with he and his mother would be staying at, I think, what's the address? 910 Maplewood, apartment 2, while they're home on what street?
789 Calder.
Calder's being rebuilt, Your Honor, which should be done in the next couple months.
What is his temporary address?
The temporary address is
910.
No, who's there?
Just his mother.
So that's his mother's address.
Correct. And he's a caretaker for her, being paid by Trinity Health. I dropped a piece of paper.
Anything else?
No, Your Honor.
All right, I set it for exam on the 2nd. I'm going to release the defendant on a $25,000 personal recognizance bond. However, a condition of that bond is he's to be placed on a home confinement GPS tether.
Thank you, Your Honor.
Thank you.
Okay. As soon as you won't be released to today, then you have to stay at your mom's place, okay? All right, you take care and we'll
Court calls the case, People versus Kanga.
This is the turning point. Judge Simpson is ignoring the serious allegations, but he is also not blindly accepting a massive bond without testing the reasoning behind it. A $4 million bond is extreme, so the judge starts examining the foundation. The defendant's criminal history, how old the convictions are, when he was released, whether he completed parole, and whether there have been new convictions since. That is the legal balancing act. The prosecution highlights public safety. The defense highlights age of prior convictions, caretaker responsibilities, housing stability, and willingness to accept GPS restrictions. In the end, Judge Simpson releases the defendant on a $25,000 personal recognizance bond, but with home confinement and GPS tether conditions. Key takeaway: bond is not supposed to be punishment before trial. It is supposed to manage risk while the case proceeds. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.